Well, welcome. We're delighted that you're all here, and particularly delighted the reason that you're all here to hear our good friend Tibor Varady. Tibor has a long association with Emory. He was a visiting professor beginning in the 80s and was appointed to our faculty as a tenured full professor in 1999. In addition, he has been a visiting professor at Cal Berkeley, Cornell, and the University of Florida. He is an internationally recognized scholar and expert on international trade, commercial transactions, and dispute resolution. He started his teaching career at the Novi Sad Law School in the former Yugoslavia. When that country began to break apart, he, an ethnic Hungarian, moved his family to Budapest, and since 1993 has been a professor of legal studies at Central European University. Currently, he is the chair of the International Business Law Program at CEU. He has served as head of department, what we would call dean, and pro-rector, what we would call provost at CEU. He also served as Minister of Justice of Yugoslavia for a year in the Panish government. He is a member of the Hague Permanent Court of Arbitration and is on a list of arbitrators of 8 arbitral institutions. He has also served as agent and counsel in 11 cases before the International Court of Justice. He is, in addition, author of over 200 articles and several books. Tibor earned his first and second law degrees from the Belgrade Law School and an LLM and SJD from Harvard. Last year, apparently anticipating my planned retirement, he announced his retirement from Emory. His assumption of emeritus status is a great loss to us, but apparently time with his grandchildren is taking precedence. We are delighted that Tibor is here today, and I am going to take full credit for arranging the blooming of spring in Atlanta as a welcoming gift to our good friend and colleague, Tibor Varady.
Thank you. Well, thank you really very much. I feel a bit moved to be here again. And thank you for all of you who made this possible. I'm also grateful to Net and other organizers for this fantastic weather, which was prepared for this occasion. And now I start understanding what does it really hint at when you see before Emory not just practice. So it's magic too, obviously. And so I feel good to be part of this magic. What I wanted to share with you are some views on some recent developments in international dispute settlement and particularly in arbitration. And I understand that we have here a group of students in international law, and also wanted to somehow posit arbitration within a system of international law. I have a case book, the 5th edition will appear maybe by end of March. My co-author, Jack Barcelona from Cornell, and I are having fun with the proofs now. And in this case book, which the first edition was in '98, we decided to try to write a transnational book. And let me tell you that one of the inspiration came from the third co-author, the late Arthur von Mehren from Harvard, who, just as our own Harold Berman, whom I met at Harvard, and he was, I think, quite instrumental in the fact that I came here. Harold Berman was telling me that when he was studying law, he was not studying American law. He was studying Connecticut law. He was at Yale. And he said that American law became a reality first in teaching. It's still not a reality excluding the reality of Georgia or Connecticut or Massachusetts, but it became teachable at some point. And our feeling was, who started writing this book, that some areas within international business law have become a reality to the extent to become teachable. There are still national laws which have some impact in international commercial arbitration, but there are some international conventions like the EU Convention, like the ICSID Convention, which are practically a law worldwide. And then there are some models. In the United States, the Uniform Commercial Code is not an American commercial code. It's a commercial code which is being accepted in various states. But there's a model, the Uniform Commercial Code. And similarly, in international commercial arbitration, you have rules, arbitration rules, and they have become more and more similar, following the same lines, the same logic, the same priorities. This year, two major rules have been reenacted. The International Chamber of Commerce in Paris has probably the best known arbitration rules. There's a new version of 2012. And a growing big power, the CIETAC, the Chinese international arbitration rules, have also a version of 2012, which will come into effect in May. And the changes are following very, very much the same logic. So the assumption that international commercial arbitration is not completely separate from some national rules. You still have rules on annulment, on setting aside, which are rules of specific countries. But these rules have been really coordinated, and they have become harmonized. So it has become a teachable reality. And this was von Mehren's idea that just as American law is first a teachable reality than a full reality, international commercial arbitration has become teachable. And actually, the book is used on all 5 continents. And so this assumption that it is possible to have this in a transnational perspective has become possible. Now, public international law is, of course, a full international reality, but there are more and more elements of law. Letters of credit is one of them. And the one I'm mostly acquainted with, international commercial arbitration, has become such a reality, and it makes sense to teach on the ground of the same case book on all 5 continents. Of course, there are other case books as well. Now, what I was also trying to share with you, I had my first arbitration cases in the early 1970s. And in that case, international commercial arbitration at that time was typically ADR, alternative dispute resolution method, which meant that the really big, really important cases were left to courts, and more simple, more straightforward, and less contentious cases went to arbitration. And this is what has changed during my lifetime. Today, international commercial arbitration has become mainstream. In many other areas, arbitration is still a typically ADR method. But in international commercial disputes, courts have now a much more limited role, and the majority of cases is submitted to arbitration as being settled by arbitration, which is a very, very significant change. Now, as a result of this, some of the characteristic and often emphasized and sometimes overemphasized advantages of arbitration have become questionable. One advantage is speed. Well, my first case was a case involving about $2,000, and the respondent did not show up because it was sort of simple for him to take the loss and to pay. So it was very quick, very simple, very inexpensive. And at that time, I mean, not as simple as this one, but many other cases I had were really simple. And that's why in all case books and all articles, you had the emphasis that arbitration has a comparative advantage because it's quick, because it's inexpensive, informal, simple. But now I'm having, for example, a case in which the amount requested is not $2,000, but $200 million. And this case has been dragging on for the fourth year. The submissions are not anymore filling 2 folders, but 5 boxes. And the attorney's fees are very considerable. The arbitrators are also paid higher fees than earlier. And so since arbitration has become mainstream, these advantages, I would not say that they disappeared. But they have become much, much less obvious and not present in every case. I would say that arbitration is still somewhat quicker, particularly because it's a one-step event. You do not have appeal, although it's possible to start annulment proceedings. But I would say that lawyers' fees are not less than in court proceedings. And of course, since big issues, highly contentious cases are involved, you have much more imagination of lawyers taking place and looking for a room of maneuver. So the classic advantages, which you will still find in most case books, are in fact not so much advantages anymore. And as a result of this, a recent study, which was a global study about why is international commercial arbitration so popular, came up with the conclusion that the major advantage is neutrality, and not speed, not informality, not inexpensive nature, but neutrality. Now, neutrality is neutrality in quite a few angles. If you have a big dispute between a French and a Bulgarian company, I can tell you the Bulgarians will not trust French courts, probably without a reason. And French will not really trust the Bulgarian court. And again, it may be without any reason. Maybe the judge who would handle the case would be perfectly fair and balanced. But you have a certain mistrust if you have bigger international cases. Then also, you have the issue of language. If a French will handle a case in Bulgaria, of course it will be in Bulgarian. So either they will have to rely on interpreters, which is not always the best solution, or they will have to hire a local lawyer. And the same would, of course, apply for a Bulgarian in France or in the United States. In the United States, a European would also have to face jury trial, and they are unfamiliar with it. And this is what, in arbitration, is somehow superseded by neutrality. Neutrality of the decision maker, but also neutrality of the rules, because rules are more or less the same. Yes, the American Arbitration Association has its own rules, but they are hardly different from the Budapest Arbitration Association or the Danish Arbitration Association or the Chinese one. Hardly. There are some differences, but not really. So somebody who is an experienced arbitrator in the United States using the ACDR rules, the American Arbitration Association rules, ICDR rules, he or she will be pretty much at home acting under the rules of the Swiss Arbitration Association, the Vienna, or the Singapore, or whichever. Because it's the same logic, the same basic balance. And of course, the language is the one which is chosen by the parties and not the official language of the court. So neutrality is not only neutrality of the decision makers, but also neutrality of the process. It's not so much part of legal systems. And it turned out that this has become the major advantage of international commercial arbitration rather than earlier advantages which have not completely vanished, but have certainly lost weight. Now, maybe this is the reason that in the past, I would say 10 years, a quite sizable number of disputes have emerged regarding yardsticks of neutrality. And some questions have emerged which are really interesting, some of them unusual, I would say. You have some very, very basic rules regarding neutrality, that the decision maker should not have family ties, should not have business ties with any of the parties. And also you have some basic rules that if there is a challenge, the person who are challenging is the decision maker, and the guy who is submitting the challenge is one of the parties. Now, all these obvious elements of the structure have become questionable during the past 10 years. Not in many cases, but yes, in some cases. Let me give you one example. There is an ICSID, International Convention for Settlement of International Investment Disputes, an ICSID case between Slovenia and a Croatian company, in which there was a challenge submitted, but against a lawyer, not the arbitrator. What happened was the following, that there was a pretty advanced stage. The case reached a pretty advanced stage, but it turned out that the Slovenian party hired a lawyer, or maybe had a lawyer earlier, but this wasn't disclosed because the lawyer was preparing. And this lawyer was in the same chamber as the chairman of the tribunal. Now, this is a reason for having doubts in neutrality and impartiality. But it is normally a reason for challenging the arbitrator. But this time it was held that since the case is already pretty much advanced, it would be more efficient to challenge the lawyer. And the challenge was successful. And it is very, very much criticized since. Because the party who nominated a lawyer said, well, look, it's part of due process that I'm nominating whomever I want to nominate. And it's only the decision maker who can be challenged. But the arbitrators had relied on a principle of immutability of the decision makers. And since the decision making started with 3 persons and there was no ground for challenge, and it was the party who later gave a ground by hiring a lawyer who was in the same chambers, it was the lawyer who had to be taken out of the process rather than a decision maker. I have to tell you that many comments have been written, and I would say that probably more comments against than pro, but it's not a big difference. Anyway, the issue arose whether a target of the challenge can be not the decision maker, but a lawyer of a party. Incidentally, the name of the lawyer is David Milden, whom I met last year in Budapest, and he was again the subject of a very odd challenge. It's another secret because the ICSID award is known. And the same David Milden was nominated as arbitrator. He was nominated by a Hungarian party owned by English owners, and on the other side there was another Hungarian party. And the other Hungarian party nominated one arbitrator. This one, who is having English owners, nominated David Milden, and the two of them nominated me to be the chairman. But David Milden was challenged on the ground that the parties agreed that the applicable law will be Hungarian law and that the language of arbitration will be English. David Milden had never had any contact with Hungarian law, which was not such a big disadvantage, because quite often arbitrators are relying on a law which is not the law in which they have their law degree. So this was a very weak challenge. But the other challenge was a more weighty one, because all documents were in Hungarian, and including someone who doesn't speak the language of arbitration really caused a lot of problem in handling the proceedings. So my reaction was, how about switching the language into English, and then it would be fine. Still, the documents would have to be translated. But the parties had an agreement, and of course you can change an agreement only by consent of both parties, and one of the parties said no. So we had Hungarian, and Milden was challenged first before the Hungarian Court of Arbitration unsuccessfully, and the challenge then was resubmitted to Hungarian court, and finally David Milden was confirmed, so the challenge was rejected. But then we decided, and David Milden was here participating, we decided unanimously that all costs incurred by this additional translation will be shouldered by the party who nominated David Milden. And then we came to a point where David Milden had a really tough ethical situation. We reached by email, by telephone conversation, which was in English, a unanimous award, which was maybe 40–45% of what the claimant was the party who nominated David Milden. And we all sort of agreed that this was about right and fair. And then in the Hungarian press, there were news that bankruptcy proceedings will start against the half-losing party, against the respondent. And I was just about to finish the draft award. And what happened was that it turned out that these bankruptcy proceedings will probably be initiated in about 5 days. And I just finished the award, which was 85 pages. And this also meant that if David Milden wants to read it, it would have, of course, to be translated into English. This would take a couple of days. And we will probably not render an award before bankruptcy proceedings would start, and this would have made a difference. And then David Milden decided not to read the award, and he signed the Hungarian version. Now, of course, this positive part was agreed. We discussed, and of course I wrote what we agreed. But a part of the duty of the arbitrator is to read the whole thing and to make amendments. So anyway, the same David Milden was the main actor of two quite interesting challenges. And in every year you have an international moot arbitration competition in Vienna. And this year the question is whether it is possible to challenge one of the arbitrators. Now, another twist came last year in Kuala Lumpur. There's a judgment of the High Court of Kuala Lumpur of March 23rd, 2011. And here again, one of these obvious elements of the whole structure of challenge have been changed. What happened here was that the challenge was submitted indeed against the arbitrator. But the challenge was not submitted by the party, but by one of the co-arbitrators. The following thing happened. That there was a case in which the respondent was probably believing that there was no jurisdiction, and the respondent was not participating. And then the three arbitrators were handling the case, but one of the arbitrators noticed that his co-arbitrator was nominated within the last few years 15 times by the same party, the party which was the claimant in this case. And the co-arbitrator knew this because there was another case in which this was raised as an issue. Can someone be nominated 15 times by the same party and yet remain impartial? But since there was no party, the party decided to abstain from the proceedings. The co-arbitrator submitted a challenge on this ground that arbitrator, whatever his name was, it's in the case, was nominated 15 times by the claimant, hence he cannot be impartial anymore. And the case reached the Kuala Lumpur Supreme Court, and the judge has a rather, I hope I'll find it, the name of the judge, he has 11 names. So it's a quite impressive name. I hope I will find it. Anyway, after a long analysis, the question was, is it possible? And the Kuala Lumpur court found that he has a vested interest in the integrity of the proceeding, and therefore it is possible for one decision maker to challenge the other decision maker. So as I said, as impartiality and neutrality are becoming the main comparative advantages of arbitration, maybe it's not completely fair to say instead, but more importantly than speed, informality, and inexpensive nature, the issues regarding impartiality and neutrality are becoming more and more complex. Completely new angles have emerged, all of them in the last couple of years. According to my best knowledge, there is no other case but the David Milden case in which someone was challenged who is a lawyer. And according to the best of my knowledge, there is no other case but this Kuala Lumpur case in which someone was challenged by the co-arbitrator rather than by a party. And in both cases, the outcome was highly questionable. But let me say something else in connection with this Kuala Lumpur case. As I said, the classic grounds for a possible challenge are grounds that someone is not having business ties or family ties. Here, however, the issue was that somebody was too often nominated by someone as arbitrator. Is this also a ground for challenge? This is not quite clear. And let me tell you that another issue, and I will stop with that issue, I will stay very shortly with that additional issue. Another issue emerged, and this is an issue whether group affiliation also matters, not personal affiliation. Let me tell you what I mean here. When the UNCITRAL model law, the UNCITRAL model law is the United Nations Commission for International Trade Law, designed a model law for international arbitration, and this model law said that no one can be disqualified on the ground of nationality. However, most arbitral institutions have taken another approach. Because most arbitral institutions have somehow come to the idea that you have some fears of bias, based not only on personal ties, but also on group affiliation. Let me tell you one case in which I was nominated by a Serbian party. A colleague, actually a friend of mine, was nominated by a Croatian party, and it was a Swiss arbitral institution. And the Swiss arbitral institution nominated a third arbitrator who was a Swiss citizen and who spoke Serbo-Croatian. Serbian Croatian is, I don't know, like English and Australian. Anyway, so it's, yeah. It's not that you cannot find some differences, but there's no problem in understanding. So the Swiss court saw that the fact that the Swiss arbitrator speaks the languages, since part of the correspondence was in Serbo-Croatian, that it would be an advantage. But it turned out that the name of this Swiss guy was Stankovic, which is a Serbian name. And the Croatian party said, well, can a Stankovic be neutral? And of course, no constitutional rule would allow you to disqualify someone on ground of his or her ethnic origin. But the Swiss Court of Arbitration thought, well, of course he cannot be disqualified, but it is our vested interest to have full trust of those who are coming to the Zurich Chamber of Commerce. So the chairman of the Zurich Chamber of Commerce invited this Mr. Stankovic and told him, look, you cannot be challenged on this ground, but how about stepping aside? And we shall probably give you another case, sort of. And he resigned. Now, 10 days ago, I was called by the ICSID, the Internet Investment Arbitration, saying that there is a case between Albania and the Greek company. And both Albania and the Greek company nominated an arbitrator, and ICSID wants to nominate me as the chairman. And you have to disclose then whether there is anything that would possibly impair your impartiality. And I never heard of the Greek company. Of course, I did hear of Albania, but not. However, I happen to be a dual citizen. One of my citizenship is Hungarian, which would be absolutely fine in this case. But my other citizenship is Serbian. And due to the Kosovo conflict, there's a bitter relationship between Albania and Serbia. So I told the ICSID that I really believe I'm impartial, but the fact that I also have a Serbian citizenship might be a problem. And I never heard from them since. Now, since it's only 10 days, maybe, but it's quite likely that they will come to the opinion that it might not be. Now, what is really gaining ground, there's a colleague of mine, he's Korean origin, he's teaching in the US, and he conducted a study about ethnic stereotypes, and he came to the conclusion that no Korean would ever accept as arbitrator an American who is of Japanese origin because of the Korean-Japanese relationship. Now, of course, you cannot challenge someone because he is an American citizen of Japanese origin. This would be in sheer defiance of any constitutional principle. But in the appointment mechanism, I have to tell you, in international commercial arbitration, it has been gaining ground. And ethnic stereotypes have been somehow heeded. It's never sufficient for a challenge. But if the parties are making appointment, or if the appointing authority, the arbitral institution, is making appointment, there is a growing trend of heeding ethnic backgrounds in order to avoid any appearance of bias. And it's a very questionable thing. On one hand, yes, it would really dispel some ideas of bias. On the other hand, you could also argue that the fact that you are heeding such things, in spite of constitutional principles, you are in some way maybe reinforcing prejudices. Whatever the final outcome, this is something what is having some ground. And actually, I'm wondering, and I wonder whether any one of you may know this, when the O.J. Simpson case was here, and here you had a very, very high profile tension between blacks and whites, the judge, as you remember, was Japanese. And all my friends in Europe said that this was on purpose. My American friends don't believe it. But then you had a civil case, and the judge was again Japanese. Now, was it wisdom? Was it coincidence? Because on one hand, yes, it might have some beneficial effect if you have a very, very strong black versus white stereotype, than to have a decision maker who is neither black nor white. Of course, if somebody would like to state a rule like this, I mean, this would be fascism. It was outright wrong. It cannot be. But was it a matter of wisdom or a weird coincidence that both in the criminal case and the civil case, the decision maker was chosen who had this neutrality? God knows. God knows. Or maybe not only God. Maybe there are some other people who know. But what may have been just an odd coincidence in the United States, and again, I would really like to dissociate myself from such stereotypes. I have to tell you that in arbitration, it has been gaining some ground, trying to eliminate me because my second citizenship is Serbian. Serbia is in bad relationship because of Kosovo. So am I not impartial anymore? And also ethnic affiliation. But this is now an issue never spelled out because, again, you cannot formally challenge someone. But in the appointment mechanism, it has been gaining some ground. And if somebody is interested, I have an article on this. I brought 3 copies if there's some interest in it. There's another case, the reverse of this, which was decided recently in England by the highest English judicial authority, which is, as I learned, not anymore the House of Lords. And this was the Gibrai versus Hashwani case. And here the issue was the following. 2 parties agreed on arbitration. And they said that the arbitrators must be members of the Ismaili community. So not only one religion, but is it a sect within the religion? One sect within the religion, and all decision makers have to be members of this sect. And the question before the English courts was whether this is possible. Okay, the parties won't so. Is this a valid? Is it unconstitutional? It was also challenged whether it has some impact on equal employment, rights of equal employment. And you had different decisions. And eventually it was held that it is not a unallowed discrimination, that it may be odd, it may be bizarre, But if the parties say that we want as arbitrators only such persons who, I don't know, are above 5'10" or who have, I don't know, gray eyes or whatever, it's pretty bizarre, but possible. So finally, in England, it has been decided that an arbitration clause which says that the decision makers can only be decision makers who are members of the Ismaili community is valid. What happened in this case was that one of the parties, in defiance of this agreement, nominated an English lord who was not a member of the Ismaili sect at all. And the question was whether this was valid, and it was held it was not valid. If the parties so agreed, this has to be the rule. So this is more or less what I wanted to share with you, and I would be very, very glad to go further on discussion. So the key advantage, according to most modern investigations, has shifted. Since arbitration has become mainstream, it is not anymore the fact that it's inexpensive, informal, and speedy. These are still relatively existing advantages, but way less than a time when the structure of cases submitted to arbitration was different. And according to most modern surveys, it is the neutrality of both decision makers and of the decision-making mechanism which is today mostly appealing. And this is why, since it has become so important, that you have very, very interesting, sometimes odd cases testing the limits of what is impartiality and who are the players here. And of course, it's very difficult to know the borders and the limits without testing them. Thank you very much. This is what I wanted to share with you. Thank you.
Do we have any questions or comments for our guest?
Yes.
Yes, I do.
Yeah.
I was surprised that one of the grounds you didn't mention as justification for arbitration, given the higher costs, as the expertise of the arbitrators as compared to local judges who may not have the same skill in commercial matters that the arbitrators do. Is that something that also plays a role?
I think it has a role. Again, you have here some interesting angles. In some countries, Spain was one of these countries, you had a rule that you have to be a lawyer to be an arbitrator. And this rule is now, has been changed. In Spain, it is not a requirement anymore to be a lawyer. And this is because there is a trend to allow simple cases which can be handled by non-lawyers as well. At the same time, the vast majority of the cases are cases in which the arbitrator is chosen not because he is a lawyer or she is a lawyer, but because she or he is an expert in a specific field, and this expertise is impossible to achieve within a court. So this is why I was hesitant to mention it. So on one hand, the regulation still allows to have arbitrators who are not lawyers at all. On the other hand, the great majority of cases has people who are experts in a very special field. Now, since arbitration is still confidential, it's very difficult to get exact data as to what extent is your assumption correct. In my own feeling, it's correct to a very, very large extent.
Yes, ma'am.
Yeah. Sorry, since my hearing is not perfect, I will come nearer.
Hi, Tibor. Thank you so much. It was marvelous talk. gave us some really wonderful examples of ethnic dynamics. I'm wondering if there is, in your experience too, some playing out of potential gender bias. Is there a gender component?
I had one, well, one of the things which has become more in focus in modern arbitration is disclosure. And there's a quite substantial number of cases in which someone is challenged on a ground which may not be a valid ground for challenge, but since this party failed to disclose this, it somehow reinforced the ground. So you have more and more cases in which disclosure is at issue. You have now a recent French case in which a very well-known arbitrator, he's of Swedish origin, and in English his name is usually pronounced it's Sigvard Jarvin. In French it's Sigvard Jarvin. And Sigvard Jarvin is, I believe, his name in Swedish. He was an attorney for Jones Day, and it turned out that he was in the Paris office, and someone from the American office was representing the party in another case, and Jarvin was the arbitrator in this case. So the issue arose that the same law firm is giving an arbitrator to one party and is representing that party. It is also true that it was a huge law firm, and Sigvard Jarvin did not know about this thing, but it was said, well, he should have known. And had he disclosed it, said the French court, maybe it would not have been so bad. But since he didn't disclose it, it was a ground for liability. So, my answer to your question is, and this is why I was telling it, is first more a joke and then something more serious. There was a French case, again, in which the issue was that of disclosure. An arbitral award was rendered, and it turned out later that the arbitrator, a lady arbitrator, was 18 years before the case the lover of one of the lawyers. And the question is whether this was a ground for challenge. And the question was, why didn't she disclose it? Well, both happened to be married at that time. And the French court had a way out, and this way out was that the challenge was, thanks God for the French court, submitted 2 days late. So they avoided the issue. And this was the joke answer. Now the serious answer is, there's an ongoing discussion about arbitrators belonging to a too narrow segment of people, and of being, from a gender point of view, too much male-oriented and not female-oriented. And in my experience, this is true. If I'm teaching at a law school, I think the number of the gender balance is more or less equal. I don't know how is it at Emory. It's certainly pretty close to that. I have had arbitration cases more than 40 years and more than 200 cases. And the number of ladies with whom I was co-arbitrator is almost negligible. And there have been articles about this. There have also been denials. But I think that by and large, this is a fact. And what is extremely difficult is I know some people who are in appointing authorities. I just cannot imagine that they are gender biased. But nevertheless, the result is somewhat gender biased. And also the question is how to overcome this. I don't know. I don't know, but this is a fact. There's also an arbitrator from India who wrote an article that the United States and Western Europe are overrepresented, and that other parts of the world, Asia, Africa, South America, are heavily underrepresented. And again, I mean, my experience has statistically very little relevance, but I think this is what I see or what I hear from friends. Now, how is this coming about and how can one deal with this? That's a very big issue, and honestly, I have no answer. The only thing I can tell you is that, yes, whatever statistics are available show that women are indeed underrepresented, yes. Very sad fact. Yes?
Well, you were saying that arbitration is on the rise. Possibly of court involvement nowadays. So one thinks that the English courts and perhaps the New York courts is doing a lot of the commercial work, for example, but I presume arbitration is taken. But as you describe it, arbitration itself is fairly complex. And is there alternative dispute resolution beyond arbitration, which is becoming popular, more mediation, for example?
When I'm saying that arbitration is taking over, I'm really focusing on international cases in which you have parties from different countries, not on commercial cases which have parties from the same country, not even if this has some international ramification. But in international cases, arbitration has become mainstream, and it was not. It was an ADR, and it has become mainstream. So this is, I think, a fact. Now, as a result of this, and it's quite logical, because arbitration was quick, informal, inexpensive, at a time when the structure of cases was such that it was conducive to simplicity and low cost. And today, when the biggest cases are also in arbitration, of course, now you have much more temptation for both lawyers and arbitrators. And it's not an unfair temptation to take another way. And you're right that other ADR methods are on the rise. And I became familiar. For example, Siemens from Germany, a big international company, and some other companies have now guidelines on dispute resolution. And they say if you have an international case, don't think of courts. Go to arbitration. But arbitration is also taking a bit too much time. So if you can handle it by mediation, it's better. So what is now also becoming a topic of studies is a so-called multi-tier dispute resolution clauses, in which the parties say we shall first try to mediate, and if it doesn't work, we go to arbitrate. And you have a lot of disputes regarding these multi-tier arbitration clauses because there is no, in many cases, it's not worked out with sufficient professional knowledge, and it is sometimes unclear whether you have to start to mediate, and to go forward to the next step, and then you have clauses that you have to start to mediate, and if all efforts fail, you can go to arbitrate. When the hell is the moment when all efforts fail? So, of course, there is a solution that you go to mediate, and if there is no solution within 16 days, you can go to arbitrate. So there are legal solutions, but this multi-tier situation has given rise to some uncomfortable cases.
Let's thank Tibor once more.
Thank you very much.